So welcome everyone. So we were doing Bharatiya Sakshya Adhiniyam. So yesterday we have taken one of the most important topics of this Adhiniyam itself, that was dying declaration, in which we have discussed in detail. So what are the circumstances during which the declaration made by the deceased person will will become a relevant fact, and under what circumstances, or under what trial, or under what civil dispute that declaration will be a relevant fact. And that condition is when his death will be in question, then that dying statement before the death by the deceased person will be a relevant fact. So as I have already explained you, so section 26, this is a hearsay evidence, which means that somebody, person who is not giving his own statement but is proving the statement of any other person. तो ਜਿਹੜਾ ਬੰਦਾ ਮਰ ਗਿਆ ਉਹ ਆਪ ਤਾਂ ਆ ਕੇ ਸਟੇਟਮੈਂਟ ਨਹੀਂ ਦੇਗਾ ਨਾ ਕਿ ਮੈਂ ਕਿੱਦਾਂ ਮਰਿਆ ਜਾਂ ਕਿੱਦਾਂ ਮਰਿਆ। ਉਹ ਸਟੇਟਮੈਂਟ ਜਾਂ ਤਾਂ ਡਾਕਟਰ ਰਿਕਾਰਡ ਕਰੇਗਾ, ਜਾਂ ਫਿਰ ਉਹਦਾ ਕਲੋਜ਼ਡ ਵਨ ਰਿਕਾਰਡ ਕਰੇਗਾ, ਜਾਂ ਕੋਈ ਉਸ ਦੇ ਸਾਹਮਣੇ ਅਟੈਸਟ ਕਰੇਗਾ ਕਿ ਮੇਰੇ ਸਾਹਮਣੇ ਉਹਨੇ ਬਿਆਨ ਦਿੱਤਾ। So that person in whose presence that statement is attested, or the person by whom it is being recorded, that person will become a witness. So that person will come before the court and he will testify before the court. So what are the circumstances of the transaction of the death, or what were the causes that led to the death of the deceased person? So you got my point. So this is a hearsay evidence. So anybody else coming before the court to testify the statement of any other person. So the general rule is that hearsay evidences are not admissible, but there are some exceptions. One exception we have already done under section 4 in form of res geste, and we are studying the second exception, that is under section 26, where the testimony of the person, the testimony of the person which has to be proved is not available because of natural reason or because of any other reason that we have studied under section 26. ठीक है जी. So the question of death, the dying declaration, was only one point in relation to section 26. There are 7 other grounds also available where testimony of any third person is becoming relevant who is not able to come before the court. You got my point? So we will be discussing those 7 conditions, but one of the most important is the only dying declaration. Rest others are minimal, so we will just finish it in quick burst. So second condition is that when any statement it is made by any person in ordinary course of business. So for example, any person having his shop who is maintaining the professional book regarding what's going on during the business hours, like what quantity of thing he has sold and what quantity of things he has purchased. So the statement made by that person during ordinary course of business will be a relevant fact. ठीक है जी. So the third statement, any statement which is against the pecuniary or proprietary interest of the person making it, or when if true it would expose him or would have exposed him to a criminal prosecution or to suit for damages. ਕਿਸੇ ਵੀ ਵਿਅਕਤੀ ਦੀ ਸਟੇਟਮੈਂਟ ਜੋ ਉਸ ਦੀ ਲਾਇਬਿਲਿਟੀ ਨੂੰ accept ਕਰ ਰਹੀ ਹੈ in relation to a civil thing, or who is confessing any crime which would lead to a criminal prosecution, so that statement will also be a relevant fact. So this was the third statement. So the fourth statement, any statement which exists, which gives existence to any public right or any custom or matter of public or general interest of the existence. ਸੋ ਕੋਈ ਵੀ ਸਟੇਟਮੈਂਟ ਕੋਈ ਜਰਨਲ ਪਬਲਿਕ ਰਾਈਟ ਨੂੰ ਪਬਲਿਕ ਕਸਟਮ ਨੂੰ ਐਗਜ਼ਿਸਟ ਕਰਾਵੇ, that statement will also be a relevant fact. ਠੀਕ ਹੈ ਜੀ. ਸੋ ਫਿਫਥ ਵਨ, any statement which leads to the existence of any relationship between two persons. Relationship ਕਿੱਦਾਂ ਹੋ ਸਕਦਾ? It can be by blood, or it can be by adoption, or it can be by marriage. ਕੋਈ ਵੀ ਕਿਸੇ ਵਿਅਕਤੀ ਦੀ statement which gives rise to existence of any relationship by blood, marriage or adoption, that statement will also be a relevant fact. ਠੀਕ ਹੈ ਜੀ. ਸੋ 5 ਹੋ ਗਏ ਨੇ. ਛੇਵਾਂ ਹੈਗਾ which statement relates to the existence of any relationship by blood, marriage or adoption between the persons deceased and is made in any will or deed. So that is a corresponding statement in relation to the fifth statement. ਜੇ ਕੋਈ relationship through will or any deed between the parties ਉੱਥੋਂ reveal ਹੋ ਰਿਹਾ ਵਾ, then that statement will also be a relevant fact. Under fifth condition, relationship ਕਿਸੇ ਵੀ statement ਤੋਂ reveal ਹੋ ਰਿਹਾ, but in sixth statement it is particular, it's being particular that the relationship is becoming aware of any will or any deed which settles the affairs between the parties. ਠੀਕ ਹੈ ਜੀ. Seventh statement is giving a general rule. ਜਦੋਂ ਵੀ ਕੋਈ deed ਜਾਂ will ਦੇ through relationship reveal ਹੋ ਰਿਹਾ ਵਾ, ਤਾਂ will ਕਿੱਦਾਂ prove ਹੋਏਗੀ? That will be according to section 11. Section 11 which deals with the proving of any custom. ਕਿੱਦਾਂ ਹੋਊਗਾ custom prove? Any particular transaction through which custom was created, modified or claimed or asserted or denied by any party. Particular circumstance or any proceeding through which custom was claimed. So in that same situation, the will be proved. So this is the seventh statement. And the last statement, eighth one, when the statement was made by a number of persons and expressed feelings or impressions on their part relevant to the matter in question. So for example, any person makes a statement before the public and the public reacts to that statement. So that reaction of public will also be a relevant fact. Even though ਹੁਣ ਪਬਲਿਕ ਨੂੰ ਆਪਾਂ ਇਕੱਲੇ ਬੰਦੇ ਨੂੰ ਤਾਂ ਬੁਲਾ ਨਹੀਂ ਸਕਦੇ ਕੋਰਟ to give their testimony. The purpose of section 26 is that when we can't call the witness but his statement is becoming relevant, to protect the evidentiary value of that person's testimony, we have created section 26 so that credibility can be given to that testimony of that person who can't come before the court due to various reasons that we have discussed yesterday. ਠੀਕ ਹੈ ਜੀ. ਸੈਕਸ਼ਨ 26 ਇੱਕ ਹੀਅਰਸੇ ਐਵੀਡੈਂਸ ਆ, ਜਿੱਥੇ ਵਿਟਨੈਸਿਸ ਆਪ ਨਹੀਂ ਆ ਸਕਦੇ, ਕੋਈ ਦੂਜਾ ਬੰਦਾ ਉਹਨਾਂ ਦੀ ਟੈਸਟਮਨੀ, ਉਹਦੀ ਸਟੇਟਮੈਂਟ ਨੂੰ is bringing before the court so that court can take cognizance of those statements or testimonies which are relevant facts. ਠੀਕ ਹੈ ਜੀ. ਇਹਦੇ 'ਚ ਮੋਸਟ ਇੰਪੋਰਟੈਂਟ ਤੁਹਾਡਾ ਡਾਇੰਗ ਡੈਕਲੇਰੇਸ਼ਨ ਹੈ, ਐਂਡ along with that there are 7 other conditions under which the statements are becoming relevant of different persons that we have discussed in detail. So let's now basically other section, now next sections are least important, so we will be covering with little flow. So we have completed section 26. Now moving to section 27. Section 27 ਕਿਹਦੇ ਨਾਲ ਡੀਲ ਕਰਦਾ ਵਾ? It states that evidence given by a witness in a judicial proceeding or before any person authorized by law to take it, it is relevant for the purpose of proving in subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found, or is incapable of giving evidence, or is kept out of the way by the adverse party, or his presence cannot be obtained without an amount of delay or expense which under the circumstances of the case the courts considers unreasonable। ठीक है जी। कोई भी ਜਦੋਂ ਸਿਵਲ ਟਰਾਇਲ ਆ ਵੈਦਰ ਕ੍ਰਿਮੀਨਲ ਟਰਾਇਲ ਆ, ਜਦੋਂ ਇੱਕ ਵਿਟਨੈਸ ਦੀ ਐਵੀਡੈਂਸ ਰਿਕਾਰਡ ਹੋ ਜਾਂਦਾ ਵਾ, ਠੀਕ ਹੈ ਜੀ, ਉਹ ਵਿਟਨੈਸ ਦਾ ਜਿਹੜਾ ਐਵੀਡੈਂਸ ਟੈਸਟੀਮਨੀ ਰਿਕਾਰਡ ਹੋ ਚੁੱਕੀ ਆ, ਦੈਟ ਟੈਸਟੀਮਨੀ ਵਿਲ ਬੀ ਅ ਰੈਲੀਵੈਂਟ ਫੈਕਟ ਡਿਊਰਿੰਗ ਦੀ ਸਬਸੀਕੁਐਂਟ ਜੁਡੀਸ਼ੀਅਲ ਪ੍ਰੋਸੀਡਿੰਗ। ਜੇ ਉਹੀ ਕੇਸ ਦੇ ਵਿੱਚ ਆ, ਉਹਦੇ ਅੱਗੇ ਵੀ ਉਹ ਰੈਲੀਵੈਂਟ ਫੈਕਟ ਹੋਊਗਾ, ਜਾਂ ਕੋਈ ਹੋਰ ਕੇਸ ਹੋਵੇ ਉੱਥੇ ਵੀ ਉਹ ਰੈਲੀਵੈਂਟ ਫੈਕਟ ਹੋ ਸਕਦਾ ਵਾ। ਦ ਰੀਜ਼ਨ ਇਜ਼ ਦੈਟ ਜੇ ਉਹ ਵਿਟਨੈਸ ਮਰ ਚੁੱਕਿਆ ਵਾ ਜਾਂ ਫਿਰ ਉਹਨੂੰ ਕੋਰਟ ਅੱਗੇ ਲਿਆਉਣਾ ਬਹੁਤ ਹੀ ਮੁਸ਼ਕਿਲ ਆ, ਈਦਰ ਬਿਕੋਜ਼ ਆਫ ਅਨਰੀਜ਼ਨੇਬਲ ਡਿਲੇ ਟੂ ਬੀ ਕਾਸਡ ਔਰ ਦੇਰ ਇਜ਼ ਲੋਟ ਆਫ ਐਕਸਪੈਂਸਿਸ ਆਫ ਦੀ ਕੋਰਟ, ਅਤੇ ਉਹ ਜਿਹੜੀ ਉਹਦੀ ਜੁਡੀਸ਼ੀਅਲ ਪ੍ਰੋਸੀਡਿੰਗ ਦੇ ਵਿੱਚ ਜਿਹੜਾ ਐਵੀਡੈਂਸ ਰਿਕਾਰਡ ਕੀਤਾ ਹੋਇਆ ਦੈਟ ਵਿਲ ਬੀ ਅ ਰੈਲੀਵੈਂਟ ਫੈਕਟ। ਠੀਕ ਹੈ ਜੀ। ਸੋ ਇਹਦੇ ਇੱਕ ਪ੍ਰੋਵਾਈਜ਼ੋ ਆ, provided that the proceeding was between the same parties or their representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross examine। ਠੀਕ ਹੈ ਜੀ। ਜਿਹੜੀ ਉਹਦੀ ਟੈਸਟਮਨੀ ਔਰ ਐਵੀਡੈਂਸ ਰਿਕਾਰਡ ਹੋਇਆ ਵਾ ਉਹ ਸੇਮ ਪ੍ਰੋਸੀਡਿੰਗ ਦੇ ਵਿੱਚ ਵੀ ਹੀ ਰੈਲੀਵੈਂਟ ਹੋਊਗਾ। ਜੇ ਉਹੀ ਸੇਮ ਪਾਰਟੀਜ਼ ਦੇ ਰਿਗਾਰਡਿੰਗ ਕੋਈ ਹੋਰ ਸੂਟ ਆ ਜਾਂ ਹੋਰ ਕ੍ਰਿਮੀਨਲ ਪ੍ਰੋਸੀਡਿੰਗ ਆ, ਦੈਨ ਅਗੇਨ that testimony or the evidence recorded by the court will be a relevant fact, provided that ਜਦੋਂ ਉਹ evidence record ਹੋਇਆ ਉਦੋਂ opposite party, that is the adverse party, got an opportunity to cross examine। ਠੀਕ ਹੈ ਜੀ। ਇਹ ਪ੍ਰੋਸੀਜਰ ਦਾ ਪ੍ਰੋਸੈਸ ਹੈ that we will be discussing under section 142। ਐਗਜ਼ਾਮੀਨੇਸ਼ਨ ਦੇ ਕੀ ਪ੍ਰੋਸੀਜਰਸ ਹੁੰਦੇ ਆ? there are 3 types of examinations। ਫਸਟ ਕੀ ਹੁੰਦਾ ਵਾ? ਚੀਫ ਐਗਜ਼ਾਮੀਨੇਸ਼ਨ, ਜੋ ਪਾਰਟੀ ਵਿਟਨੈਸ ਨੂੰ ਕਾਲ ਕਰਦੀ ਆ ਉਹ ਚੀਫ ਐਗਜ਼ਾਮਿਨ ਕਰਦੀ ਆ। ਦੈਨ ਦੀ ਅਡਵਰਸ ਪਾਰਟੀ ਗੈਟਸ ਐਨ ਓਪਰਚੁਨਿਟੀ ਟੂ ਕ੍ਰੋਸ ਐਗਜ਼ਾਮਿਨ। ਕ੍ਰੋਸ ਐਗਜ਼ਾਮਿਨ ਮੀਨਸ ਟੂ ਪੁੱਟ ਦ ਕੁਐਸਚਨਸ ਬਿਫੋਰ ਦ ਵਿਟਨੈਸ ਟੂ ਟੈਸਟ ਹਿਜ਼ ਵੈਰੈਸਿਟੀ, ਉਹਦੀ ਸੱਚਾਈ ਨੂੰ ਚੈੱਕ ਕਰਨਾ, ਜਾਂ ਫਿਰ ਟੂ ਬ੍ਰੀਚ ਹਿਜ਼ ਕ੍ਰੈਡਿਟ, ਉਹਦੀ ਸ਼੍ਰੇ ਨੂੰ ਘਟਾਉਣਾ ਤਾਂ ਕਿ ਕੋਰਟ ਉਹਦੇ 'ਤੇ ਰਿਲਾਈ ਨਾ ਕਰੇ। ਸੋ ਅੰਡਰ ਸੈਕਸ਼ਨ 27 ਦ ਕੰਡੀਸ਼ਨ ਇਜ਼ ਦੈਟ ਦ ਅਡਵਰਸ ਪਾਰਟੀ must have got the opportunity to cross examine him, then only the evidence or the testimony which is being recorded in the previous suit between the same parties will be a relevant fact। ਠੀਕ ਹੈ ਜੀ। ਇਹਦੀ ਐਕਸਪਲੇਨੇਸ਼ਨ ਜ਼ਰੂਰ ਪੜ੍ਹਨੀ ਹੈ ਤੁਸੀਂ। ਇਹਦੇ 'ਚ a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within this section। criminal ਇਨਕੁਆਇਰੀ ਔਰ ਟਰਾਇਲ ਇਹ ਕਿਹਦੇ ਬਿਟਵੀਨ ਪ੍ਰੋਸੀਡਿੰਗ ਆ? ਦੈਟ ਇਜ਼ ਬਿਟਵੀਨ ਪ੍ਰੋਸੀਕਿਊਸ਼ਨ ਐਂਡ ਅਕਿਊਜ਼ਡ। ਦਿਸ ਇਜ਼ ਦੀ ਕੁਐਸਚਨ ਆਈ ਫੇਸਡ ਇਨ ਮਾਈ ਜੁਡੀਸ਼ੀਅਲ ਐਗਜ਼ਾਮ, ਆਈ ਗੈਸ ਇਨ ਦੀ ਰਾਜਸਥਾਨ। ਸੋ ਐਕਚੁਅਲੀ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨੇਸ਼ਨਸ ਵੀ ਕੇਅਰਫੁਲੀ ਰੀਡ ਕਰਨੀਆਂ ਚਾਹੀਦੀਆਂ ਨੇ। ਸੋ ਦ ਕੁਐਸਚਨ ਵਿਲ ਬੀ ਦੈਟ criminal trial or inquiry shall be deemed to proceeding between whom under section 27 of Bharatiya Sakshya Adhiniyam। So it will be a proceeding between prosecution and accused person। ठीक है जी। So now section 28, that is also very simple and general section, which states that any entries in the books of records or accounts which are maintained by the business persons in regular course of business, or it can be even maintained in electronic form, that will be relevant, but they are not sufficient alone to charge any person with liability। ਉਹ ਰੈਲੀਵੈਂਟ ਹੋਣਗੇ। ਸਪੋਜ਼ ਕਿਸੇ ਦੁਕਾਨਦਾਰ ਨੇ ਆਪਣੇ ਬੁੱਕ ਆਫ ਅਕਾਊਂਟਸ 'ਚ ਲਿਖਿਆ ਦੈਟ ਆਈ ਹੈਵ ਟੂ ਗੈਟ ਵੀ ਮੇਰਾ ਡਿਊ ਪੈਂਡਿੰਗ ਆ ਫਰੋਮ ਏ ਆਫ ₹10,000। ਸੋ ਦੈਟ ਐਂਟਰੀ ਵਿਲ ਬੀ ਅ ਰੈਲੀਵੈਂਟ ਫੈਕਟ, ਬਟ ਉਹਦੇ ਬੇਸਿਸ ਇਕੱਲੇ ਉਹਦੇ ਬੇਸਿਸ 'ਤੇ ਆਪਾਂ ਲਾਇਬਿਲਿਟੀ ਡਿਸਾਈਡ ਨਹੀਂ ਕਰ ਸਕਦੇ ਔਨ ਦਾ ਏ। ਦੇਰ ਮਸਟ ਬੀ ਰਿਕੁਆਇਰਮੈਂਟ ਆਫ ਅਦਰ ਐਵੀਡੈਂਸਿਸ ਟੂ ਫਿਕਸ ਦ ਲਾਇਬਿਲਿਟੀ ਆਫ ਏ। ਠੀਕ ਹੈ ਜੀ। ਉਹ ਰੈਲੀਵੈਂਟ ਹੋਊਗਾ ਬਟ ਨਾਟ ਸਫੀਸ਼ੀਐਂਟ, ਅਲੋਨ ਸਫੀਸ਼ੀਐਂਟ ਨਹੀਂ ਹੋਊਗਾ। ਠੀਕ ਹੈ ਜੀ। ਸੋ ਸੈਕਸ਼ਨ 29 which is of same nature as compared to section 28, but under section 29 the person who is maintaining book of records or book of accounts is a public servant, So any entry made by the public servant during his official duty, while discharging his official duty, so that entry in book of accounts or book of records will be a relevant fact. So again, so under section 29 there is a simple thing, कोई भी entry that will be relevant fact, electronically भी हो सकती है, it can be physically also. So section 30, which deals with the relevancy of maps, charts and plans. Any map, chart or plan issued by the authority of the government will also be a relevant fact. ठीक है जी. So and that will also be considered, it shall be considered genuine. presumption होगी कोर्ट के अंडर, कोई भी मैप जो कि प्रिपेयर किया हुआ गवर्नमेंट अथॉरिटी ने will be a relevant fact, and along with that it shall be presumed to be true. ਜੇ ਉਹਨੂੰ false declare ਕਰਨਾ, then the burden of proof will be on that party who wants to prove it wrong. ठीक है जी. So section 31 deals with any acts or notifications. So acts means any laws made by the legislature, and all the notifications, executive notifications issued by the government will also be a relevant facts. So section 32, it deals with the relevancy of statements as to any law contained in law books, including electronic or digital form. कोई भी law declare किया any book ने regarding any decision of Supreme Court or any decision of High Court, that will also be a relevant fact. Section 31 ਦੇ under ਆ acts and notifications, and under section 32 these are the books of laws and digital records which deals with the decisions of the courts. ठीक है जी. So we have completed till section 32 and we have completed major chunk of the relevant facts. So now we are only left with the relevancy of previous judgments, how previous judgments will be relevant in your current case, and after that we will be covering the expert opinion. That is also very important topic, how expert opinion will be a relevant fact, and at last we will be doing how character is a relevant fact in a civil or criminal trial. So we are left with 3 topics in case of relevant facts. What facts are relevant? So we will be completing tomorrow or day after tomorrow of relevant facts. Then after that we will be starting with types of evidences, be it oral evidence or documentary evidence. So अपनी ਹੁਣ 3 चीज़ां रह गईਆਂ सिर्फ in case of relevant facts, that is the previous judgments, expert opinion and character. So that's all for today. So if you face any doubt in relation to dying declaration or any unimportant sections, if you want any detail or any kind of other assistance, you can just message me, or you can just put down the comment below the video so that I can help you out appropriately.